So Alvin Bragg, he makes his filing in New York. We talked about that was due after the Trump team had filed a motion to dismiss. So how does Alvin Bragg, how would he like to see this go? Well, maybe just stay it. Now, remember, this case was already stayed, and we call it tolling in the law, where basically the clock stops right on the edge. I mean, I think he was running out of time, and that's why he came up with that notion of adding a felony that they could not really determine what the felony was, that was a federal crime, to the state crime, so that they could do these felony charges against President Trump. So they would like to enter a stay, and that would handle the competing interest. I think he's saying that while there's times in office we're respecting the rule of law and the president of the United States, but once they are no longer president, there's no legal barrier to sentencing them. Okay, so I think that's unlikely, but usually that's like all you'd hear from them. Really, is that kind of an argument? Basically, keep it stayed, and they'd hope and pray, right? The second argument is one, Will, that we have found, and this is a unique one because it's not an argument that New York utilizes at all, and in fact, New York utilizes a law that is actually the opposite of this law. This is the so-called Alabama rule, Will. I'd love for you to tell people, as an Alabaman, what is the Alabama rule? Because you know what? We know a lot of law at the ACLJ, but I'm not barred in all 50 states, and certainly this is the first time for me seeing the Alabama law certainly cited in a New York DA's case.
So what the district attorney here is arguing before the court is that they should follow a procedure that happens when a defendant dies before final judgment is entered through the appeals process. So what happens in most states, including New York, is abatement ab initio. And that rule states that the judgment of conviction is vacated and the indictment is dismissed on the ground that the defendant's death makes any further appeal impossible. So effectively, if you die and can't continue the legal process of appeal, then they just dismiss the case and it goes away. What he's arguing is something different, which is called the Alabama rule. It's very novel to Alabama. And it's that after a defendant dies and he is found guilty, but before the conviction comes through final appellate process, the court places in the record of the case a notation to the effect that the conviction removed the presumption of innocence, but was neither affirmed nor reversed on appeal because the defendant died. Effectively, he wants to keep that convicted felon title for President Trump through a notation in the court, but it would then close the case and take away President Trump's ability to appeal it further, essentially saying that by becoming president, he is in lines with someone who has died in the course of the appeals process. It's wild. I've read a lot, not as much as you in legal briefs, but I've never seen something like this proposed.
So you're not guilty, but they do acknowledge that you might be found not guilty if you hadn't, quote, died. Now, of course, President Trump is not dying by being president of the United States. I'm not even sure if he would accept this and wouldn't want to appeal this himself. Maybe he'd just shrug his shoulders and say, crazy New York case, done, finally, over, goodbye, if they want to go to this Alabama rule. But you could also see a way where you think about it and go, you know what, no, I'm not going to let you change this. It doesn't seem right for court systems to be able to randomly change their normal practice where they have to go out and find some rule in Alabama that gets to say that you were found guilty, but you just weren't ever sentenced and you never got your appeals on that.
Alvin Bragg might make a very interesting and even brilliant law professor, but he is not equipped to ensure that justice is done. So what he has offered is a breathtakingly bizarre plan to keep the Trump campaign finance conviction alive and well during Trump's presidency. Why does he want to do this? Because he wants to impeach Donald Trump in the court of public opinion. So he wants to keep this abatement by death concept, which he has pulled from the files of Alabama, and he's trying to introduce them into New York, even though there is absolutely zero precedent in New York for accepting this particular rule. And I think Judge Marchand should reject it. And if not, Donald Trump and his legal team should make sure they appeal this approach.
Alvin Bragg just throwing the whole kitchen sink out there, Will, hoping and probably praying that he gets something to stick against President Trump that he can put up on his wall.
It's clear that Alvin Bragg thinks the judge may even side with the president and just get it out of his court. So he's trying, as you said, throwing everything at the wall to try and see what sticks. And when you read from this is on page 32 of his filing, where he admitted that New York doesn't follow this Alabama rule. But he says, in this way, the Alabama rule abates the criminal proceedings without vacating the underlying conviction or dismissing the indictment, and says it makes sense to borrow from the manner in which courts address abatement because many of the defendant's arguments here parallel the arguments made in favor of dismissal and vacatur upon a defendant's death. So he's trying to put that in the judge's mind that what they're arguing about him becoming president and not being able to continue the appeals or other processes in court because he's sitting president, they're arguing a parallel argument to the death of a defendant. It's just wild to see him even put in writing, while New York follows this, you should try this new thing. I don't typically think judges like to be the one that tries out the novel theory unless they really just want to make a name for themselves. But Judge Merchan has already had so much pressure and spotlight on him during this, trying to take this novel path. I hope he doesn't choose that. I think what the right thing to do is just say, get this out of here.
The way D.A. Bragg would like to keep this going against President Trump, or at least have it on him in perpetuity, and say basically, well, we'll choose the one state that sometimes applies a rule called the Alabama rule, which we don't even know really looking at if that's even always done there. I think it's just an option that's done there. It may be like some truly heinous cases where then you have someone who passes away and it says they were convicted. It does say there that they didn't have the ability to appeal because they are dead. But of course, Donald Trump is alive. What the problem is not that Alvin Bragg wants to declare Donald Trump dead from becoming president of the United States, so thus taking him out of their jurisdiction. It's that Alvin Bragg's cases against Donald Trump are dead. And they were bad, dead cases before he even got a conviction from a jury, which would not be difficult where this trial was held. And it was already getting serious questioning on appeal about how he tried to put those federal charges along with these state misdemeanors and falsifying business records, which I really don't want to keep talking about, but I do like to underscore to you that they will not let it go unless they are going to be forced by a court to let it go. They want this to stick on President Trump, and really that's so they can then use it for their own political purposes in the future, because as they say, then President Trump won't be affected by this at all. But of course, the left would love to still call him a convicted felon.